case is State versus. Good morning. Our next case is State versus Anderson, and we will hear from the appellant.
May it please the court. Good morning again, Your Honors. I'm Kathy Vandenberg from the Appellate Defenders, here for Darrell Anderson. I'd like to introduce Attorney Dawn Blagrove, the Executive Director of Emancipate NC and amicus in this case. One of the many problems with life without parole in all its forms is that it's disproportionately imposed on children of color. Ms. Blagrove is here to address that specific problem, and I'll use whatever time remains after her remarks for rebuttal.
May it please the court. I'm Attorney Dawn Blagrove, the Executive Director of Emancipate NC. Juvenile life without parole in North Carolina is an example of structural racism. This form of structural racism manifests through laws written in a race-neutral way. However, the actual outcome, that 91.5% of children sentenced to LWOP in North Carolina are children of color, the vast majority being Black. The racist outcome created by the laws is evident. As outlined in our brief, all criminal justice actors contribute to these disparities. Studies into the source of racial disparity in juvenile LWOP sentences have concluded it is not because one group is more often arrested for homicides than the other. Rather, the disparity necessarily arises at some point after arrest and is most likely attributable to either higher conviction rates for non-whites or to racially disparate charging practices. The fact that a child's race is predictive of whether they receive the harshest punishment possible and that North Carolina has imposed the sentence in such a racially polarized way is sufficient grounds to find that this practice violates the state's constitution's prohibition on cruel or unusual punishment. Because accountability for the disparate outcomes are diffuse, it is an intractable problem that cannot be solved through a targeted or itemized order. Instead, we implore the court to take the necessary steps to ensure fairness and equity in juvenile sentencing. We ask that you cut out whatever the insidious cancer is in our system that metastasizes racist outcomes. Nothing less than the integrity of our court system is at stake. A sentence that is consistently imposed in such a disparate way undermines the public trust in our legal system, as former Chief Justice Beasley stated clearly in June of 2020. 91.5% speaks much less about the children we locked in cages and so much more about us. I stand before you today advocating for one of the children represented in that 91.5%, Darrell Tristan Anderson. While practicing at North Carolina Prisoners Legal Services more than a decade ago, I represented Darrell during one of his post-conviction proceedings. I've always remembered him for so many reasons, but one specifically was because his middle name was Tristan. I remember being struck by how much love, hope, and aspiration went into selecting such a stately middle name. I say his whole name today because as a Black mother, I know how we agonize over naming our babies. We want to give them monikers that sound worthy of respect and of dignity because we know we are birthing them into a country that will deny them both without a second thought. At Darrell's resentencing hearing, he stated the following: I ask that today you do not make me another statistic. You have the power to change the story, and I ask you to please do so. We argue that the racist outcomes of juvenile sentencing in North Carolina is reason enough to find juvenile LWOP and de facto life sentences unconstitutional. We implore you to change the story for Darrell and all the other children like him. Federal courts recognize that North Carolina's sentencing is vastly discretionary because judges are not limited in any fashion when deciding whether to impose consecutive or concurrent sentences. For Darrell and other Black youth who were not yet 18 at the time of their offenses and whose sentences were ordered by the trial courts to run consecutively, this discretion is the difference between the possibility of redemption and the prospect of living an entire life and dying in prison. Did a deeply damaged child participate in a horrible act? Yes. This was undoubtedly an awful crime. Does the state of North Carolina need to hold him responsible? Yes. Does that mean, though, that we should decide that he will spend his entire life behind prison walls without any opportunity to earn redemption through parole? The only humane answer is no. There's no way to claim equity or fairness in a process when the results so disproportionately deny life and liberty to Black children. The United States is shamefully one of only 4 countries in the entire world that still imposes LWOP for juveniles. North Carolina ranks among 10 states that combine to account for 85% of juvenile LWOP sentences nationwide. More specifically, North Carolina has sentenced 94 children to life without the possibility of parole or the functional equivalent. In doing so, North Carolina has sent a message that these children's lives have no meaningful value and they can be disposed of forever. But most insidiously, implying these children deserve to grow up, grow old, and die in a state of perpetual captivity. My children, 2 college-aged Black women thriving and walking into a beautiful adulthood, deserve no more credit for being successful than Darrell deserves blame for the dark road that he traveled. They were children. Neither Darrell nor my girls had any control over who raised them, who nurtured their spirits, who fed their souls, or illuminated their life path. As a result, no child, not mine, not yours, not Darrell, can fairly be held irredeemable for the choices that they made before reaching adulthood. It takes a village to raise a child. Darrell's village, by no fault of his own, was lacking because of multiple intertwined societal ills and interpersonal harms. His village was unable to offer him the chance for a successful life. The United States Supreme Court has said states are free to move away from permitting imposition of juvenile LWOP sentences and recently noted that many have. North Carolina should join them. If the prohibition against cruel and unusual punishment means anything, it should mean it will not impose punishments that have been outlawed the world over and rejected by most United States jurisdictions. This court has the power and the supporting legal precedent to give Darrell the one thing he and so many children like him never had: a chance to change the story of their lives. Darrell was born in 1984 as the youngest of 4 children. He lived with his brother, 2 sisters, and both parents. But his father, James Anderson Sr., proved to be a destructive force in Darrell's life. Darrell's mom and older siblings took responsibility for Darrell's care, but they could not protect him or themselves from the trauma and pain of growing up in their home. Darrell's father had a job, but was often unable to pay the bills, and at times, the family would do without even basic needs. Darrell's dad was not equipped to support his family and turned to drugs to deaden the pain and violence and torture of his family in a misguided and a destructive attempt to reclaim his manhood. The generational curse of systemic and institutional racism can only be interrupted by giving Darrell and other people like him a chance for hope. Darrell's dad regularly smoked crack cocaine at home and would choke his children. Darrell was choked by his father for the first time at 5 years old. Parents pour into their children from the cup that they drink. Darrell's father, well, he drank from a cup filled with self-loathing and emasculation. By 7 years old, Darrell was literally and figuratively drinking from his father's cup when his father began forcing him to drink alcohol. Darrell lived in a home where his father abused the rest of his family as well, including sexually molesting his 2 sisters. Unsurprisingly, being raised in a state of chaos, torture, and trauma, Darrell acted out and frequently fought with his older brothers. He was eventually diagnosed with ADHD and prescribed Ritalin. In 2008, Darrell's father was convicted of sexually abusing a child outside of the nuclear family. Darrell, like so many Black children, ended up seeing his father, his primary role model, in prison. The impact of this modeling cannot be overstated. A child becomes what he can imagine. This is the unseen toll of systemic and institutional racism. It is the toll of a constellation of societal ills: domestic violence, substance abuse, poverty, the things that convince the oppressed that they have no future, that their life has no value. North Carolina's criminal justice system reinforces the devaluing of Black lives by affirming that some of our children are disposable. When Darrell was 11, his older brother participated in a robbery and a murder. Darrell's older cousin, Eddie Neely, was his only friend, and the two would spend time together at Darrell's highly dysfunctional parents' home. Eddie used and dealt cocaine, and, according to Darrell's sister, would tell Darrell to do all his bad things. Eddie was just using Darrell to do his dirty work. Darrell and Eddie used drugs extensively during Darrell's teens years. When Darrell's dad continued to abuse him, at one point attacking him with an axe. Indeed, Darrell and Eddie were both high on crack cocaine at the time of the heinous crime. No one knows the exact moment when the road of Darrell's young life led to the carceral system, just like no one knows the exact source of the racial disparities in juvenile LWOP and equivalent sentences. Yet, unseen societal forces played a central role in fostering both. Sentencing data indicates that juvenile LWOP sentences are disproportionately, and in North Carolina, overwhelmingly imposed against Black youth. Put plainly, North Carolina sentences more babies to a life in prison than many other states, and does it in a way resulting in a racially disparate outcome. Just like the compounded trauma and torture of Darrell's young life are multifaceted and hard to address, so too are the elements of systemic and institutional racism that results in so many Black children being caged for life in North Carolina. The inability to pinpoint and extricate from the criminal justice system the point where racism rears its head furthers the need to prohibit imposition of these draconian sentences. We may be unable to correct the process and rid it of demonstrably racist outcomes, but we have an obligation to mitigate the harm the process ultimately causes. No child is disposable. Every person should be given the opportunity to be more than their worst act, especially especially when they committed their worst act as a child. Thank you.
Thank you, counsel. I'm assuming that you want to reserve the rest of your time for rebuttal. At this time, we'll hear from the appellee.
Good morning again, Your Honors. May it please the court, my name is Kimberly Callahan, and I represent the state in this matter. Race should have no role in punishment decisions. We acknowledge that historically, juvenile life without parole sentences have disproportionately been received by defendants of color. Important policy issues arise from these concerns, and our office has weighed in on those. To date, the General Assembly has declined to address it. The heinous facts of this case, however, leave no doubt that race did not affect the outcome of this particular case. Just a little over a week away from his 18th birthday, defendant retrieved a shotgun from his closet in order to rob one of his known friends, Myra Hedgepath. When the robbery went awry, he ended up killing both Edward Bard and Myra by taking a shotgun and shooting them in the head. The narrow question of law that is presented to this court in this appeal is whether the trial court was constitutionally permitted to hold defendant accountable for committing 2 counts of first-degree murder by imposing consecutive life sentences with parole eligibility after 50 years. And the answer to that question must be yes. At the resentencing hearing, the trial court considered the mitigating evidence the defendant presented and credited it, and determined that sentences of life with parole were appropriate under our statutes. However, it denied the defendant's motion to run the sentences concurrently because it concluded that consecutive sentences reflect the atrocious nature of the crimes perpetuated against multiple victims. The defendant here received the type of individualized sentencing that the Eighth Amendment and Miller and its progeny demand. The Court of Appeals below correctly held that the sentences imposed by the trial court, though significant, are not unconstitutional. The Court of Appeals majority opinion should be affirmed in this case.
Can I just ask you about the trial court's reasoning in this particular case? Because didn't the trial court believe that they were barred from imposing concurrent sentences?
Yes, Your Honor. He made a number of findings that he was barred due to previous motions for appropriate relief that were filed. He also felt that he may be constricted by the plea agreement and made a number of findings, but then ultimately said, well, even if I had jurisdiction to enter concurrent sentences, I would decline to do so because of the nature of these offenses. Now, the Court of Appeals in this case, down below, found that the trial court misapprehended whether it had the discretion to impose concurrent or consecutive sentences, and that case has been, there was an agreement between the majority and the dissent to remand it for reconsideration of whether to impose concurrent or consecutive sentences. However, the majority and dissent disagreed at what sentences could be constitutionally permitted to be imposed upon remand, and that is the question that we have before you today.
Did the state seek review of that, or were we to affirm? Is that issue before us, or regardless of our ruling today, it will go back to the trial court to exercise its discretion?
That's correct, Your Honor. We did not challenge that portion of the Court of Appeals.
Which raised the question for me when I read this in the materials presented for our consideration here. Until we've got a final judgment, how do we know what sentence we've got? And if we don't know what sentence we've actually got, then how can we, generally you don't decide constitutional issues unless you have to. So given the situation in which we find ourselves, what do we do?
Well, the procedural posture of this case is certainly unique. We do know what sentences the trial court imposed, and we do have
Right.
final judgments.
And the trial court's been ordered to at least reconsider potentially at least one aspect of those decisions, but if it reached a decision contrary to the one that it made initially and suggested that it might make again, that might moot this case, wouldn't it?
Well, I mean, I think what you're getting at is this question really ripe for review at this juncture?
That's probably a more legally correct way of saying what I said.
And I think in terms of at least a judicial economy, it would be prudent to go ahead and answer the question so that when it gets remanded, the trial court knows what sentences are constitutionally permitted. Because if this court decides,
But that's starting to sound to me kind of like an advisory opinion that we generally don't do.
fair enough, Your Honor, that
I mean, I may be missing something, but that's, at least an inference that one could draw from what you said.
and perhaps I should have pursued that argument, but unfortunately I did not. So at the moment, all I have is
Sure.
that,
We have what we have.
we have what we have.
Right. So proceed.
The legal arguments in this appeal are almost identical to those made in the previous case in Kelleher. Both the dissent and the defendant in this case exclusively rely on Kelleher to argue that this defendant's sentences are unconstitutional. So I don't have any intention to repeat the arguments that have already been made, but there are a few distinctions worth noting. We have in this case, and Justice Morgan, you alluded to this in the earlier case, the Court of Appeals majority relying on life expectancy tables. And the state's been criticized as to not discussing or arguing that the Court of Appeals properly considered those. However, down below, the state argued in Kelleher and in this case, in all three cases that are before you today, that using life expectancy tables is problematic for a number of reasons. We've discussed some of those already. Life expectancy data is speculative. It's not reliable. No person can be expected, they could live the next 50 years or they could die the next day. There's simply not a workable standard for this court to use. And basing it on life expectancy.
Well, that mean they're an actuarial determination made upon the basis of, they're based upon an actuarial determination made on the basis of looking at a large number of individual lives and reaching a projection based on an aggregate, right? The mortuary tables, life expectancy tables?
Yes, Your Honor, and the Court of Appeals used those in this case, and I would like to make it clear that the state has argued that's not really an appropriate standard to use. It becomes problematic. De facto life without parole sentences are problematic in and of itself because, as has already been discussed, there is no constitutional guidance for where to demarcate where the lines should be drawn.
Assuming there is a recognition, though, of a de facto life without parole, to follow up on my learned colleague Justice Hudson's question from the earlier case argued, State versus Kelleher, is that at least some bona fide effort to try to quantify, to some measure at least, what could constitute a de facto life without parole sentence?
I mean, I think it was a bona fide attempt to do so, but I would point out to the court that that was an alternative argument that was made in the majority. The primary holding was that that Miller has never held that a life with parole sentence is unconstitutional, and that while these sentences certainly are significant, they are not unconstitutional under the Eighth Amendment. And then it goes on to alternatively hold that, assuming arguendo, we were to recognize these 50 years in prison is not de facto life without parole based on the life expectancy tables.
In this particular case, the record shows that if the trial court's consecutive sentences, life being given as it was, life with parole, that the juvenile would be eligible for parole when he is 67 years old. Is that, in this case, a de facto life without parole determination?
No, Your Honor, it's not.
Is that based on the Constitution? Is that based on life expectancy, or otherwise, what's the state's position on that?
Well, the quintessential question in this case is, are these sentences unconstitutional under the Eighth Amendment? And the Eighth Amendment prohibits 3 sentences as it relates to juvenile offenders: capital punishment, mandatory life without parole for juveniles who commit murder, and life without parole for non-homicide offenders. This case does not fit into any of those categories. What we have here is the trial court making a discretionary decision to sentence defendant to consecutive sentences for both of his crimes. He has an opportunity to gain meaningful release. His opportunity to get paroled at 67 makes his sentences fundamentally different than the second severest punishment on the books, which is life without parole. Life without parole, you have no hope, no chance of ever getting out of prison. You have no chance of ever living any type of life, and you will die in prison. That is not the same as the punishment that is imposed here.
So you know, you use this term, I think, in your answer to Justice Morgan, and if you didn't, you got close to it. You know, the expression everybody keeps coming back to is, in trying to deal with the question that Justice Morgan was asking you about, is the language from Graham about meaningful opportunity to obtain release. What does the state contend that a meaningful opportunity to obtain release consists of, assuming that it's relevant?
Yeah, I think it's alluded to both in Graham and Montgomery that a meaningful opportunity for release is a chance at parole. I think the main dispute.
So it's just in your view, and then it's a chance to obtain parole, period.
Correct, Your Honor.
Okay.
Because life without parole, which is the second severest punishment, you do not have that opportunity. So any sentence that allows you to have some parole eligibility at some point is materially distinguishable. One of the other distinctions that I wanted to make here is there was no explicit finding of whether this particular defendant was redeemable or not, and of course, according to Jones, that was not required. But just because the trial court found that life with parole sentences would be appropriate for each murder conviction, that does not mean that the trial court is not constitutionally permitted to hold the defendant accountable for both of these crimes. The defendant's argument regarding the scope of the North Carolina Constitution is not properly before this court. The decision in the Court of Appeals applied this court's holding in Green and read the Eighth Amendment and the North Carolina Constitution together. So while the defendant did raise the argument that he raises now, that the North Carolina Constitution gives some broader protection to juveniles because of the textual differences, that argument was not accepted by the dissent. There was no petition for discretionary review to review that issue in this particular case, and so it's not properly before this case, and in any event, the defendant hasn't given you any extraordinary reasons or compelling reasons why it should change this court's longstanding precedent and interpreting those provisions the same. Your Honors, unless there are any further questions that you have about the state's position in this case, I would simply ask that the the Court of Appeals majority be affirmed.
Thank you, counsel.
Thank you.
Rebuttal.
Thank you. We've shown that North Carolina's children who have received life without parole sentences are overwhelmingly children of color. The North Carolina Advocates for Justice amicus brief shows that children sent to prison are also overwhelmingly poor. The Disability Rights amicus brief shows that a majority of children who land in prison had traumatic events in their childhood. The state has not contested any of this data. The fact that race and poverty and trauma are highly correlated with juvenile life without parole sentence should give this court more reason to limit extreme punishments for children in our state. Regardless of who's to blame for these disparities, they exist now on your watch. This court must make a moral judgment under the federal or the state constitution about what punishments are cruel. Sending redeemable children to prison without hope of release or reintegration is immoral, and imposing that punishment disproportionately against children of color is especially immoral. I'd like to talk a little bit more about the remedy. It is within this court's ability to construe the juvenile life without parole statute as being the sole statute that covers these sentences. It's sort of taken for granted in adult court we have the statute that allows concurrent or consecutive sentences, and that's what was used in this case. And we haven't argued specifically about that statute, but that's what the trial court did, was decided it could make juvenile life with parole consecutive to itself. And this court has to construe statutes in a constitutional way. And this court can construe our statute that allows juvenile life with parole or life without parole as the only two options, as being the only option for juveniles in this case, and saying that if we bring in this other statute that lets you stack sentences, that becomes unconstitutional, and for that reason, we're not going to construe it that way.
Are you now arguing that consecutive sentences in juvenile cases are Eighth Amendment violations?
In this case, where you're using the juvenile life statute for homicides and trying to stack them 25 plus 25, yes, that interpretation, which was used in this case and Mr. Kelleher's case, I contend leads to an unconstitutional result, and the statute should be construed by this court to get to a constitutional result. That's what Judge McGee said.
Is that argument anywhere in your brief, Ms. Vandenberg?
Not discussing the number of the statute, but discussing the fact that it was consecutive.
Your brief argued that the effect here was to create a de facto sentence of life imprisonment without parole. I didn't see any argument in your brief. Ultimate question is, what did I miss? I didn't see anything in your brief that argued that there was any statutory deficiency in what happened here.
I wouldn't call it a statutory deficiency because there's nothing wrong with it.
Deficiency would include an unconstitutional decision per
Well,
se.
I mean, maybe we're going in circles. I didn't make a specific argument about that.
Okay.
Judge McGee did. I mean, at the end of her dissent, at least in Kelleher, and I don't remember if she mentioned it in this case, but she said you can't, she went with 25 because she said, I can't do 50 because 50 is too long, and that's my only other option under this statute.
Well, I don't want to get too far in the weeds, but it seems to me there is a difference between arguing that a consecutive sentence for a juvenile convicted of multiple offenses is per se an Eighth Amendment violation as compared to arguing that on the facts of a particular case, the two sentences that were ordered to be served consecutively resulted in an impermissible sentence. The second I got you as arguing. The first I did not get you as arguing.
Well, I wouldn't say that I'm arguing it in just this case. I'm saying any of these cases where there are 2 life sentences.
But are you saying that any consecutive sentence imposed in a juvenile case is a violation of the Eighth Amendment?
I am not arguing that
Okay,
in this case.
that's what I thought I heard you
Okay,
say. That's why I
okay,
was asking.
Okay.
Thank you.
I think that we should not be presuming that the legislature would hold differently on the de facto question. The legislature could have said, it's fine to stack sentences, right? It's not like they'd never heard of doing that before. They were silent on it. That doesn't mean that they approve of 25 plus 25. And I think the fact that they chose 25, which is a very severe sentence for a teenager, can be used as evidence that that is the right number. Especially because it's a floor. You know, you were saying earlier, Justice Ervin, that it's both a floor and a ceiling, but I don't agree with that. It is a life sentence that goes for someone's entire life, whatever that's going to be.
Right.
It's an opportunity, and the opportunity should be set at a time that's fair to the least. If you're talking about everybody, it should be set at the time that will give the person with the least blameworthiness a chance to get out. If we're not doing this as an individual sentence, if you want to allow people who are rehabilitated to get out and have a chance at a life, 25 years, the legislature has said, is a sort of a sweet spot between how do you hold someone accountable for a very long time, a severe punishment, and still give them a chance to reintegrate. If there are no more questions about that, I'll conclude by saying that North Carolina ought to protect its children, and North Carolina ought to help those children who, like Darrell, were not protected. Darrell's life has value. At resentencing, the trial court said he was convinced Darrell could have been in a different place if not for his terrible upbringing. It's immoral to punish Darrell excessively and to destroy any reasonable hope that he might one day rejoin society. We ask that you reverse the Court of Appeals opinion and give Darrell a chance at release from prison after he has served 25 years. Thank you.
Thank you. Thank you to all counsel. Madam Clerk.